So once again, thank you everyone for joining the conference and welcome to session D6, CADTCP's Principles of Drug Treatment Courts, presented by Jen Graham. My name is Ken Zolatar. I am joined by my colleague Aaron Paquette, and we will be your facilitators for this session. Before we give Jen the floor, I have some quick housekeeping notes. First, I'd like to draw your attention to the bottom of your screen. As you're already practicing, you can use the chat feature to submit questions. Please type, if you're able to, question in all caps in the chat so that we can flag those questions. It'll make it easier to find them as you're going through. You can also share your other thoughts in the chat as well. Share your insights, share some ideas, build and connect. That's what this conference is all about. And so there will be time at the end of the presentation as well as during the presentation to ask questions. So you don't need to wait till the end. You can throw them into that chat right away. Also, please ensure your microphone is on mute so that it is easy for Jen to present. Please note that the session is being recorded and it will be uploaded to the conference website for future viewing by those who have registered for the conference. You'll be able to access the platform and the recording for 90 days. Also, there is an evaluation. We will put that in the chat as well for this presentation, and your feedback is much appreciated as we use it to inform future events. And lastly, we ask you to engage respectfully and thoughtfully and consider the impact of your words and interactions with others. As facilitators, we will not tolerate abusive or inappropriate behavior and will ensure that anyone who engages in such behavior is removed from the session. So, housekeeping complete. I would now like to introduce our presenter, Jen Graham from the Canadian Association of Drug Treatment Court Professionals. Take it away, Jen.
Thank you so much, Ken, and hi, everyone. Just a few announcements from me before we dive in. I am ill, so I've got hot water and honey here. I lost my voice this morning, so I'll probably take some breaks throughout just to regain some stamina. So I would really welcome questions and comments to form more of a discussion to give my voice a bit of a break. And also, I'd really love to hear what all of you have to say. The other thing that adds a bit more fun to this afternoon is my 6-year-old is also homesick today. So if you hear someone in the background, that is what's happening. And hopefully he will keep himself entertained, but this is life these days, right? So I'm Jen Graham. I'm really happy to be here. I was just sharing with Ken and Aaron before the rest of you joined that drug treatment court is actually my favorite topic when it relates to work. I saw that there's some people who have experience in drug treatment courts in the chat. Thank you for those of you who have said where you're from. I'm wondering first if you either feel free to speak out if you'd like or add in the chat. Is there anybody that currently works in a drug treatment court, or is there anybody who's on the line who's hoping to get one up and running in your area? Your support coordinator from Guelph Drug Treatment Court. Excellent. Thank you so much for joining. I think that program is relatively new, if I'm not mistaken. And we have someone else who's on the committee for the DTC in Barrie. Also wonderful. Thank you so much for coming today. Woodstock DTC, excellent. That's great. Oxford DTC, court clinician, Oxford. That's out London way, if I'm not mistaken. Yes, wonderful. And someone else is in the preliminary steps of onboarding. Where is that, Lindsay, that you're located?
We're in Thunder Bay.
Thank you. That's wonderful. I'm happy to hear that. You guys have some great programs in a brand new courthouse up there. So it's great that that hopefully a DTC is going to come up and running. Hopefully some of the information that I share with all of you today will help you in that journey. Okay, so Sudbury, lots of conversations on the need and interest, but you don't have one yet. That's too bad you don't have one, but hopefully some information today can get you on the right path. Waterloo Region DTC. Excellent. So thank you, all of you, for answering. I know it's challenging when we're in a virtual world, trying to have interactive discussion. So I do appreciate the effort. So I'm just going to move over to my slides here. So here's what I'm hoping to talk about. What is the CADTCP, first of all, and its history, the history of drug treatment courts and why they're important and what they do and how they differ from other courts. I'm going to talk about the key principles and models that have been established by the CADTCP, and a little bit about each of those principles and how those principles can lead to success in a drug treatment court. I'm going to talk about the importance, but I don't want to say the word absence, but the lack of evaluations in DTCs. That's a problem for a lot of the programs across the country. Also goes hand in hand with funding and the lack of funding that a lot of us are experiencing. I'm going to talk about the importance of community partnerships. And then for some people who are trying to get theirs up and running, I'll talk about the program in and outs. And we'll get a bit more specific there. And then I'll talk about the stigma that is related to problematic substance use and drug treatment courts, and the importance of cultural competency when you're trying to either stand up a court or you're working with people in an already established court. And then client feedback, because it's always nice to hear success stories. And as Ken mentioned, we can go through questions at any time. Please don't be shy. Like I said, it'll give me a bit of a break from speaking if you want to ask any questions. And the other thing I wanted to mention is I have two screens going right now, so that's why I'm looking to my right. So don't feel like I'm getting distracted. I'm right here with you. Okay, so what are drug treatment courts and why should they be involved in the justice system? So broadly speaking, and sorry, I should have said this at the outset, my role outside of the Canadian Association of Drug Treatment Court Professionals is I'm a Crown attorney in Brampton, and I prosecute criminal code offenses. So I've been on our Brampton Drug Treatment Court for about 7 years now, almost since its inception. And I'm one of the two co-leads in our program now. So a lot of the anecdotal examples that I'll be giving you will be from our drug treatment court, but the more principled part of the discussion will be from the perspective of the CADTCP. And if anyone wants me to draw that distinction at any time, I'm happy to do so. So generally speaking, drug treatment courts, they change lives and they improve communities. And that's evident, and that's going to be my argument. That's evident for many, many ways. So oftentimes, drug treatment courts are seen as an option of last resort. As many of 90% of drug treatment court participants have a really long history of prior convictions. There are people who come in to programs who have, at least a dozen pages on their criminal record. In the 50s or 60s in terms of outstanding charges. Of course, there's also people who come in who have no criminal record, but oftentimes it's people who have a lengthy history in the criminal justice system who come into the drug treatment court. The CADTCP has found that up to 70% of drug treatment court clients suffer from depression or anxiety disorders, as well as their addiction. And many also are living with PTSD symptoms and other acute and chronic health needs. We just heard an amazing keynote speech from Kerry Gladue, and obviously a lot of his journey and what he shared comes from intergenerational trauma, but he also spoke to these other concurrent issues that he experienced as a result of his own trauma and, of course, the intergenerational trauma. And we have found in drug treatment courts that, as I said, up to 70% of people come in with these complex issues that they're trying to sort out. And their cases are very unique and should be treated as such. Also, in a lot of jurisdictions, up to 95% of people who come into drug treatment court are unemployed. when they come into the program. And 22% of those participants report that criminal activity is their sole source of income. 90% of people tested on a level of risk inventory as high or very high, a risk to reoffend. And in some courts across the country, 75% of participants have had unsuccessful treatment experiences prior to entering a DTC. Also, it's important to note that 86% or more of drug treatment court participants began using drugs before their 18th birthday, some starting as young as 12. So a lot of the participants that come in, as I mentioned, come in as a last resort. They have been living in the system, surviving in the justice system, and addiction is one of the things that's perpetuating their reoffending. And they come upon this program, or they're referred to this program, and oftentimes when they're successful, it's because there's no other options left, and that's their intrinsic motivation to be able to get through the program. It's a common misnomer, I would argue, across the country and even across the continent. I've spent a lot of time discussing drug treatment court with people in the US as well, and they operate a lot differently than we do, but drug treatment courts are not an easier or softer way to make it through the criminal justice system. For those of you who don't know, DTCs provide intensive treatment services, case management, and judicial supervision. The participants are released on a very strict set of bail conditions that are crafted to be useful and a tool for success for the individual. Each week, DTC participants are required to attend court. They're required to do urine screens, to meet with a caseworker, and to meet with a counselor. Those are the 4 main things that they're required to do at a minimum every single week. And for someone who's deep in the throes of addiction, that's extremely challenging and to be able to do. And it often takes many, many months of building those levels of success until they're able to accomplish all of those things. Also, a lot of drug treatment courts have a minimum term for people in the program. Ours in Brampton, for example, you have to be in the program for a minimum of 6 months before you can graduate. I'll get to what graduation looks like later on. But so imagine doing all 4 of those things every single week for a minimum of 6 months. That could be really challenging, and it is really challenging for most of our clients. There's, of course, residential treatment programs. I know in Brampton, for example, it's not a requirement of the program that a participant or a client attend a residential treatment program. It's an option if they choose to pursue that. We, of course, would support them. But of course, that's not easy either. Any type of treatment program, whether it's inpatient or outpatient, is extremely challenging. So again, not the easy way out. And in order to graduate, I'll just go over it very briefly, and I'll go into it later on, but another way to look at it, it's not an easy way out, is that in order to graduate, at least in Brampton, the person must be substance-free for a minimum of 3 months, and that is demonstrated through negative urine samples that are produced twice a week. They are not to pick up any new charges. They must have stable housing, and also they must be involved in the community, whether that be through work or volunteerism, and that be also for a minimum of 3 months. So those are all pretty challenging things to establish, but certainly if the client is able to get there, leads them down the path of success as they move out of the program. DTCs reduce substance use and crime. One of the examples I like to, sorry, that's another point. So they, of course, reduce substance use. So there's across the country, there is a lot of discussion about which approach is better, and it's not just in the DTC context, but in addictions as a whole, but whether or not these types of programs should be abstinence-based or based in harm reduction. And I can only speak to our program. We have a harm reduction-based philosophy. And I have seen, actually, I'll answer that question now, Farhan. So Farhan asked, what happens if housing can't be guaranteed? I'm assuming you mean when I was talking about leading towards graduation, and assuming that was what you're asking, it is a requirement for graduation. So oftentimes we all know there's, a lack of available housing, particularly right now. Oftentimes that will lengthen the term that somebody is in drug treatment court, as we'll be supporting them in trying to find somewhere stable to live for a long-term period. And most clients are okay with that because they want to have that support of the program, understanding that oftentimes not having stable housing could lead to relapse. So for our program, it is a requirement, and they don't have to show proof of a landlord-tenant agreement or anything like that, but we know through interaction with the client on a weekly basis whether or not they have found a safe and stable place to live. So I hope that answers your question. We don't guarantee housing as a program. We support them in either connecting them with services to help locate stable housing, or to help them, pursue stable housing on their own, whether it be give them access to online searches at the office or those sorts of things. So, there's many different ways that we can support them in doing that. But it's absolutely still a requirement from our perspective. I would say another reason why justice should be involved in drug treatment courts is if the program is successful and if a client makes it through, given that part of the program is that they don't continue to pick up new charges, obviously the rate of recidivism will go down, and taxpayers' money that would be used for further investigations, for prosecutions, for trials, and even to house somebody if they're incarcerated goes down significantly. I'll use this example. In our program, we had a client who entered, on 66 charges at one time. And ultimately that client did graduate. And just think about it. If you're coming in on 66 charges, let's even just say that's 20 different sets of charges. I can't remember the number. On 20 different sets of charges, that means that was 20 different investigations by the police, 20 different preparations for prosecution from the Crown's office, 20 different trials that include oftentimes civilians, police witnesses, court staff, judges, court time, all that kind of stuff. And then arguably up to 20 different sentences that are imposed. So that would have an effect on probation and also potential corrections facilities. So for that one client, I don't know what the number is, but the number is astronomical that this system as a whole saved because this person chose to participate in the program. So if you look at the success of that one client and you multiply that by the number of successes across the country for people who do participate in drug treatment courts, simply from a cost-benefit analysis, the benefits are astronomical. I'm just scrolling down through my notes here. Okay, one of the other things that drug treatment courts do is that they help reunite families. Across the country, about 50% of DTC participants are able to reestablish a real connection with supportive family members after entering the program and are able to sustain that relationship after they exit the program. We find oftentimes that When a new party comes into the program, they're quite often alone. And if they're doing well within the first few months, you'll start to see family members come in to show support, and those people who do and ultimately get to graduation. It's oftentimes a family affair where everyone is there to celebrate the success of the client, and it's really wonderful to see, because you know that they're set up to do well with their family members' support as they move forward in their new life of being substance free. And of course, if the graduate or person working towards graduation is able to work, then that obviously is good for society as well. Working people will spend money, and from a capitalist perspective, that is all good. We won't dive into politics too much, but that also helps as well. Okay, so what is this? Pardon me. What is the CADTCP? It's a really long acronym, and it's an even longer title. It stands for Canadian Association of Drug Treatment Court Professionals. So this is a group of people dedicated to the development of drug treatment courts and the support of alternative justice models across Canada. We bring together different professionals to both raise awareness, impact public policy, and to demonstrate how firsthand knowledge and participation in these programs can save lives, and as I just mentioned, can save the health and justice system's money. The mission of the CADTCP it's stated to provide information, education, standards, expertise, and public awareness of drug treatment courts and other alternative justice models. It's been a couple years, but a few years ago, CADTCP used to host annual conferences to discuss drug treatment courts, and we're hoping that we get back to doing that sometime in the near future, because the topics are limitless, what you could talk about with these particular unique courts. Oops, sorry. So as I mentioned, I'm going to talk a little bit about principles. So these are the 13 key principles that were established by the CADTCP. These are tried and tested principles, tried and true principles that the association articulates. If a program is able to adhere to these 13 key principles, then there will be success. So the first principle is that of a marriage of treatment services with the court. So what this means is a collaboration of both systems is superior to each working alone. We talk about this all the time, the issues of silos, particularly between justice and health, and working together in a team approach really does help the client move forward through their journey of recovery. Another part of this marriage between these two parties is the client gets immediate treatment, and they also get ongoing judicial supervision. So each week they have to appear before a dedicated DTC judge who knows their story and knows their journey to date and knows where they're at within their treatment. So having that collaboration or team approach between the two worlds really helps the client succeed as they move through their journey. The second is non-adversarial approach to decisions. So all team members meet in a pre-court meeting prior to discuss each and every client. And what that looks like, at least in ours, and I believe most programs across the country, is our community partners provide us with reports. So for example, my DTC sits tomorrow. So this afternoon, I've been getting reports from our community partners, that being a counselor and a caseworker, for every single client. And in those reports, you'll get a weekly update. You'll get results of urine screens, and then anything particular to the client that was discussed last week that we need to follow up on. And then on Friday morning for us, we meet together for usually about 3 hours, and we discuss each and every client at length with all the team members present. And all of the decisions that we make we come to a consensus before we go into court and have a discussion with the client or relay a message that we have agreed upon in the pre-meeting. So for example, if the client is doing really well and we just want to relay a message of positive encouragement, then that's something that, it's easy to agree on that, and you go in and do that in court. Oftentimes there's quite a bit of debate, heated debate that goes on in these pre-court meetings. And that's okay. That's a good space for it. You have different people looking at things through different lenses. We all have the same common goal, but sometimes different ways of getting there. But ultimately, we work, as I mentioned, on a consensus basis. And what will happen is we'll just keep going round and round and round until we agree what the message should be to the client once we enter court. And it's the judge primarily who, once in court, delivers the message on behalf of the team. The third is eligible offenders are identified early. So this is where when there's a good partnership with the police service or services in your region, the police can oftentimes identify somebody who they think would be a good candidate for a drug treatment court. Or if hopefully you have crowns who are invested in the program as well, and at screening they can identify people who may be good candidates, and then they can apply. So the earlier they're able to get into the program, obviously the better off they are from a treatment and recovery perspective, but also the better off society is from a economic perspective and from a safety perspective. What makes someone a good candidate for DTC? That's a great question. So there are criteria for eligibility. I'll go through them in detail later on, but generally speaking, it's mostly property offenses. So think like an LCBO theft, a smash and grab, or stealing something from a locker or that sort of things. So when I see somebody as a vetting crown come in with a new set of LCBO thefts or a new set of industrial smash and grabs, those sorts of things, my mind automatically goes to, is this somebody who has problematic substance use and could be a good candidate for DTC? And I will oftentimes either relay that to the defense lawyer if they have one, or we have a dedicated duty counsel as well, and then they'll reach out to the person and see if drug treatment court is something that they want to consider. From a Crown's perspective, when I'm assessing eligibility, there also has to be a nexus between the offense when it was committed and the problematic substance use. So basically, were they using at the time of the offense, or did they commit the offense for the purpose of using? So did they steal alcohol to sell in order to buy drugs? Like, there has to be a nexus. If there isn't a nexus, then they would best be served in the other stream of the justice system. And I'll go into it a little bit later, but it's probably prudent at this point, at least in my program, we have a strict limit of 20 people that it can be allowed in a program. So the spaces are a hot commodity. So we are pretty critical when we're looking at an application and eligibility to see if someone is a good fit for the program. But I know not everyone operates on a wait list, so I'll just put that out there for mine. Question: any recommendations on how to buy in from defense counsel with weekly court appearances? This can sometimes deter private counsel. That's also a great question. I used to be a defense lawyer, so I totally get that. I'll kind of answer two ways. So one, once your client, assuming the client wants in, number one, once your client's in, because we have a dedicated duty counsel, private counsel are not required to attend court every week. They are more than welcome to attend the pre-meeting and court every week, but we acknowledge as a program that it's really challenging on a defense lawyer and to be able to attend every single week for these types of things. So what we do to manage that is, because we have a dedicated duty counsel, They are most often the person that represents the client during the pre-meeting and in court, unless there is something big that's occurring. So, for example, is there a need for a sanction? So, if something's happened and the client, we're talking about whether or not a sanction is appropriate, then we invite the private counsel to come in if they're available that week. If not, we make a time where I'll discuss it with them privately and invite them to the next week. So if it's like kind of a usual run of the mill week, then we kind of just go with duty counsel, obviously with the consent of the client. But if it's something important, like I said, sanction, expulsion, graduation, those sorts of things, we always make sure that private counsel is involved, or that the client has the option to have their private counsel involved, which of course is their choice. Right, and then, okay, so Karen says, I worked in the Ottawa DTC and found that there was a lot of non-helpful debate about urine screens that turned adversarial and really worked against treatment. Treatment had no lever to work with clients, and the debates were non-scientific and ridiculous. That's really unfortunate. Correct me if I'm wrong, Karen, but I believe that the Ottawa DTC operates an abstinent-based program, or did. Yes. Okay. So I'm guessing that's where a lot of the debate runs. I could see that being really challenging. I think I would never try to tell another program how to run their program, but I have heard, and that's how I knew that it was an abstinent-based program. I have heard that there are challenges with that program, for like that being one of the reasons. I'm not sure how to get around that. I can absolutely see how it will become adversarial, and how it would be almost like trying to catch the particular client in a lie. If they're using and they're expected to be abstinent, of course, I mean, human nature, of course, they're going to likely be not truthful about using, and then the urine screen would show that they weren't being truthful. And I could see how there would be a lot of breakdown in confidence in the program, and also pose a lot of problems for treatment with the counselors and such. I'm happy to dive into that a little bit more if you like, but I definitely appreciate that is a challenge. Okay, did we talk about treatment services? I think that's relatively obvious why key principles treatment services are essential. They're basically the heart of any DTC, because, for example, I'm a lawyer. I don't know how to treat problematic substance use. We defer to the experts in that. So the partnership between the two is absolutely essential, and the trust between the two is absolutely essential. Urine testing, we kind of just dove into it a bit, but for our program, we don't do random. We do twice a week urine testing, and that is a requirement of our program. We do not expect the urine screens to come back negative until either the client advises that they ought to be negative, and we're approaching graduation. We understand, at least in our program, that addiction is an ongoing journey, and that there can be relapses. And for us, as long as the client is honest with either their counselor and or the court, then we're all content to move forward on that basis. Sorry, the last one on this slide is incentives and sanctions. So, a range of both of these things should be developed in order for a client to know what they're working towards. And sanctions, those are always challenging, but the advice of the CADTCP is that they should be swift in imposing sanctions. They shouldn't be deferred, but they should also be flexible. so that they meet the needs of the particular client. Ongoing judicial supervision, I think we talked about that. They check in every week with the court, and the judge is the one that kind of discusses the weekly message that was determined by the team. Evaluation is extremely important. That also leads to funding. I'll get into that a little bit later. Partnerships with the community, talked about that a bit before. It's extremely important to have partnerships with as many people as possible within the community. And sorry, I skipped over interdisciplinary training. This is just that it's really important that the DTC members work as a team and that we continue our own education in order to make sure that we are the best that we can be in order to support the clients as they move through the program. The importance of case management, I think that is obvious, but it's certainly a key principle. The program must be flexible, so it must be responsive to the needs of the particular client. And those are always individualized. And I think in my experience anyways, that when a client sees or hears that the program is attempting to be flexible and to meet them where they're at, that they're more likely to buy in, to understand and believe that we truly do care about them and care about their well-being and their success. And that, you know, it's not a one-size-fits-all scenario. And then planning for aftercare. So, you know, aftercare services are just as important as the path towards being substance-free and abstinent. And if there isn't an aftercare plan in place, oftentimes that leads to a lot of issues for the client. So on the topic of evaluations, it's critical. It's a critical piece for drug treatment course success. It helps with funding. If funding is being sought, evidence secured in the form of evaluation can and should be used when making those applications for funding. The lack of program funding for many DTCs nationwide has created a challenge for upholding the particular principle that I just talked about. And part of the evaluation process ought to include client feedback, because really it's them that we're serving. And if there are things that we can do better than when we're doing our self-evaluations, that's certainly something that needs to be considered. On the issue of funding, only 6 programs across Canada have been approved for federal funding. And I can speak to my experience as a Brampton Drug Treatment Crown. We are not funded. I have applied for so many grants in order to get funding for our program, and none of them have been successful, which is really unfortunate. Still hopeful that one day that'll happen, but I know that me as a Crown, the judges, the dedicated duty counsel, and the court staff, the issue of funding doesn't really affect us specifically because we're getting paid regardless. In my experience, it's been the community partners who are there, the caseworkers and the counselors specifically, who are there every single week, that it really does affect their organizations and their ability to invest further in the program. I mentioned a couple minutes ago that our program has a wait list. The only reason we have a wait list is because our casework partners, they only have capacity for 20 people. They can't take on more clients because, again, we're not funded. So that certainly places a limitation on how programs are able to work. Of course, there are far more than 20 people in the community who would benefit from this type of program. But, you know, that's one of the arguments we make when we're applying for further funding. So that really is a problem. It's something that's kind of a work in progress. So our community partners are integral and are really the heart of any drug treatment court program. So for us, this is how we have it broken down. And I understand this is similar for a lot of programs, that the caseworker manages urine screens, and meaning gets the results from them, communicates with the labs and such. They assist with housing searches. They assist with job searches, drafting resumes. Our caseworkers are phenomenal. They they do so much to assist our clients. They basically support the clients for anything that's not specifically counseling related. Our counselor, we have a partner organization that we work with, and they support the clients through addiction specific counseling and also concurrent counseling, which is often the case for a lot of the clients. And then our other community partners that are just as important, as we have people that work in housing. We have people, places of worship. Oftentimes those places will come in to support clients on a weekly basis. Or, we have community partners where we know we could send people for community service hours and that sort of thing. So to have those types of connections is also really important. What I'm really excited about in our program is that of a therapy dog. We had one last week come, and it was amazing to see the reaction of the clients when they saw the therapy dog there. It was really wonderful. So our perspective is the more the better. The more people who want to help and support, the better. As long as it's useful to the clients and doesn't detract or distract, then the more the merrier. So Sam has a question. Do DTCs have partnerships with dual diagnosis justice coordinators or developmental service workers? In short, neither people with those titles. I know that for our program, we do not have a partnership with a developmental service worker. Because we haven't had that specific need, acknowledging that of course there would be clients that do have that need. I think that would be something that we would have to dive into specifically in our region, in our community. On the dual diagnosis justice coordinator, we don't have someone that works in that specific role, but I could certainly see the value to that. And I think that also kind of links up with the issue of funding or not funding. But that would certainly be amazing if we did have somebody with that capacity in order to support the program and the clients. So I'll really quickly go through, remember I talked about going through the ins and outs of the program. So, and I could let you know if anyone wants any precedents or anything. I'm happy to email them to anybody, so you can reach out to me by email if you're looking to start up a program and you want to have a look at any of our forms. So what applications consist of for our program is that of a waiver. It's pretty intense waiver. It's like 11 pages or something like that. I won't go into it, but it's long and intense. There's an application form and Crown questionnaire. That's actually one form together. And then we have an after plea consent form. So those are all filed with the court at the time of entry into the program. So the process to enter the program is, we talked about referrals a little bit before. Those can come from anywhere. They can come from a judge, they can come from police, they can come from prisoner escort officers, they can come from duty council, community partners, crowns, defense lawyers. They can come from anywhere. We're happy to take a referral from anybody, family members even. So once a referral comes in, then we get the application form and the waivers that I just mentioned. Then the Crown will screen whether or not it's eligible. Then we take the application to the pre-court meeting and we talk about the prospective client and talk about whether or not we think they would be a good fit. Then assuming, we progress through this, there's an in-court interview with whoever the judge is. In our case, we have 3 judges, dedicated DTC judges. So there's an in-court interview with the judge where the client can have that interaction on a bit more of a personal level with the judge. They can kind of get to know the program a little bit. And then, of course, once they're in the program, they progress with their weekly meetings. And then we have a 30-day probation period. And this is really important. If there's any lawyers on the call, I don't know if there are, but this is really important, at least from the legal perspective. So within those 30 days, both the client and the program have an opportunity to see whether or not this is a fit. So At the 30-day mark, we have a brief but formal hearing where we ask the client, is this a program that you want to continue with? If they say yes, then they're locked in until they either leave the program on their own by way of sentence or graduation, or until they're expelled from the program. If they say that they don't want to stay in the program, all of the guilty pleas that they made upon entry into the program are struck, and they are sent back into the regular stream. So at that 30-day mark, the team also has the opportunity to discuss and then share whether or not we think the client is a good fit. And this happens quite often where one or the other side will say, I don't think this is a good fit. And then the client leaves the program. There's no hard feelings, there's no bridges burned. They can always reapply and try again when they're ready. But that's worked really well for us in our programs, the 30-day probationary period. Eligibility. So we talked about this a couple minutes ago, but there's a lot of things that are not eligible. So any residential break and enter is not eligible. Any significant crime of violence, anything involving a domestic partner, anything that alleging impaired operation of a motor vehicle, any trafficking in a drug or substance, and any crime against children. So there's a lot of things that are not eligible. But as I mentioned before, it's mostly property related offenses that are the rounders, as I call them, unfortunate term, but that come into the program because it's their need to consume their drug of choice that perpetuates their criminality. And if we're able to stop or curb their need for that drug, then everyone wins, as I mentioned earlier. Program expectations. Honesty, 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 honesty. That is basically the only thing that we care about. If you're honest with us, then we can work with you. The other things that are expected is that you make your court appearances, your appointments, you do your urine screens. But if you're honest with us about why you didn't do any of those things, then we could still work with you. So really, it's all about honesty. And we acknowledge that we have to gain the trust of the client just as much as they have to gain our trust. So we're honest with them, and then they're honest with us, hopefully. And in our success stories, that's usually what happens. Graduation criteria, I went through these earlier, so I won't do it again, but it's all the same. I did talk about, oh, thank you, Erin. Okay, so there's a question. You mentioned data collection as being an essential component. Does your program collect race-based data? Are clients able to access culturally appropriate services and programs? Amazing question, Erin. So yes and no. We actually really struggle on the data collection front in my program. We are not consistent, and that's something that we know that we have to work on, and we raise it at almost every steering committee meeting, but not much moves on it. So that it was something that we need to work on. One of the things we also talk about when we're talking about data collection is race-based data collection. Brampton is extremely diverse, and we have become more aware of the need to self-evaluate on how we're dealing with people who identify from a different race or culture, and to be able to make sure that we have appropriate services for them. So to answer kind of the last part of the question, are there culturally appropriate services available? Absolutely. So we have quite a few clients for, I'd say at this point about at least 40%, maybe 50% that are South Asian, and they identify as such, and we will make sure that we connect them with services that they want to be connected with. Of course, they're not all the same, but we will ask them specifically, would you prefer to have to go to a different service provider? Would you feel more comfortable there? Sometimes they say yes, sometimes they say no, but of course that's your prerogative. And we do the same thing with all of the other, all the clients actually, not just whether or not they present as somebody from a visible minority or anything like that, but we ask all the clients, who would you feel comfortable meeting with? Is there a particular gender or race or culture or anything that you would feel comfortable sharing your experience with? Because again, it goes back to, this is their journey. And just because, you know, for example, I'm white, I'm female, I could appreciate how that may be challenging for some people, me being the crown or a sign of authority. So we try our best to work on the things that we can't change in our program, like me, to accommodate in other ways and try and make clients feel comfortable in other ways, I would say, that are a lot more important. Like the counseling is where the real work happens. So if they're comfortable in that realm, I think what we have found is that generally speaking, the clients are comfortable coming to court and seeing like a white crown, for example. But we really are aware of that, and we're really trying hard to work on that. But it is something we need to work on, and it's something that we're lacking. So stigma, this is huge. I know I'm running out of time and kind of running out of my voice, but stigma is really, really important. The stigma for people coming into the program, the fear of being misunderstood as one of the clients, both by the court and by sometimes service providers, that's a real issue, and something that we try and stay in tune with, because you know, that's one of the barriers that we need to break down in order for a client to be successful. One of the ways we try to break through professional stigma is through continued education. That happens all the time. There's a lot of really great resources available for legal people, for non-legal people, health people, like this conference, for example. There's a lot of other great places to get that further education. And it's probably from most of you who are on this call that will be teaching me these types of things. So that's really important to break down the stigma. And just the overall point, it's really important that reducing that stigma is a priority for all participants in the program. So not just the professionals, the clients, the court staff, everybody. It's really important. Okay, so culturally competent counseling and case management. I kind of just touched on this a little bit before, but you know, this is really a cornerstone as well to the success of a program, regardless of where you find yourselves in the province or the country, and it should be specific to each program. So what we have found is that when we invite different members of the community into the program, whether it's to support a client or to educate us as a program about their culture and how whatever the particular issue is handled in their culture, it is fantastic for everybody. Everybody learns, everyone grows, and it's really, really important. As I've said a couple of times, it's not a one-size-fits-all scenario. And having cultural competency in all forms of the program, particularly counseling and case management, of course, but across the whole board is really, really important. I'm totally losing my voice, so you guys can read this slide if you like. I'll just have a little sip of tea. Thank you for your patience. So client comments, this is where we get to feel really good about the things that we do. So I've included some of the client comments that we have from our program here. There's also some really great resources. There's a book that's been published by Justice Barnes. It's called People, Places, and Things, and it's basically a compilation of stories, essays, poems, artwork, so many things from people who have participated in the program. We're really fortunate in our program that a lot of our clients are really great artists, and they have gifted their art to the program. So every Friday when we sit, their art is displayed proudly in our court, and it's really important for us to reflect on the successes and failures of the court in order to continue to improve as we move forward. So there's some comments. Again, I'm losing my voice, but I know you can all read. So go ahead and read through those. And I think my last slide, I'll leave this one up because that's really a feel good. Oh, actually, I included the logo of our Brampton Drug Treatment Court program on this slide because it was created by clients. So we, quite a few years ago, sought to create a website, and we wanted a logo for our court. So we put it out there to clients and said, this is your court, this is your program. Why don't you, if you want to work on something, design something for us. And there was, I think, about 4 or 5 submissions. And this is 2 submissions that were included together. So one was of the scales of justice, that was one. And then the other one was the bird with the olive branches. So we had a graphic designer work to put the logos together. And I think it's really beautiful. And we're really proud that it was some of our clients who created our logo for us, which we now display proudly. So back to client comments, in case anyone wants to read those. So does anyone have any questions or comments? I think I'm talked out, guys. Anywhere you think that as a whole, drug treatment courts can improve across the country, the province, I can take it back to the CADTCP. I'm one of the directors there. I'm happy to do that.
Okay.
Thanks for asking your questions throughout as well. That gave me a bit of a break, and I like having a bit more of a conversation as well.
Yes. Thank you, Jen, for taking the time and sharing all of this wonderful information with us.
We got a question. Ken, we have a question.
Oh, I'm sorry. We're not going to wrap up yet. There's questions.
We just saw it. Lance, you have a question. We'll ask Lance first, and Jenny will come to you. I'm so excited.
Can you hear me?
Yes.
Perfect. Hi there. Yeah, I don't have a ton of experience with drug treatment court, but I've heard a couple things about it. Like, it's super, super cool. I really like that it exists. But I find that the one thing that I guess sort of leaves me saddened at some level, though, is that this sort of more intensive sort of court process is only offered to potentially kind of lower risk, lower violence sorts of offenders, which I don't know what the equivalent is for someone who is a domestic violence offender or has quite assaultive behavior or whatever else. But the fact that there's as much time and intentionality taken to address these situations, you mentioned the financial benefit to this, and let alone obviously the outcomes that a lot of the comments and a lot of the feedback that I've heard from people who've been in it have been extremely positive. So it's too bad it's not like the approach isn't more generalized across other sort of types of charges and that sort of thing. I guess that's just a comment, but thank you so much for your presentation. I appreciate it.
Thanks, Lance. Yeah, we often get that comment as well, specifically as it relates to impaired operation. A lot of people who their problematic substance is alcohol, and they will drive. It's unfortunate. There's certainly a strong argument to be made that a lot more offenses should be included. And unfortunately, at this point, a lot of it comes down to policy. And for example, with the impaireds, there's a mandatory minimum sentence, right? So our hands are tied a bit across the country when it comes to those types of things by what's set out in the criminal code. But I totally hear what you're saying, because we're kind of then separating problematic substance use from many categories of offenses where I'm sure it is a very real reason. So thank you for that.
Well, yeah, and it sounds like the outcomes, again, other types of offenses, you could probably have, again, some great outcomes with, again, potentially limiting the financial cost of all the police recurringly attending domestic violence calls with the same couples, and like all these sorts of things that are, but I mean, obviously these are larger conversations than a presentation today, but nonetheless, I do appreciate it. I love drug treatment court. Now that I learned more about it, this is amazing.
Me too. I love it too. we have a question from Jenny. It says, have you seen clients come through with indictable offenses with minimal or no criminal history? Yes. Yes, we have. Do you mean at the point of like come through and graduate and stay with no criminal record, or are you saying like people with a long history of criminality?
So I'm from Niagara region, and we are just starting up. We've only had 1 day of mental health and drug treatment court. So very unfamiliar to the process, people, and how it's going to play out. And of course, there are a lot of ideas and people who are strong advocates and want to see great change, but then also seeing another side of saying, well, you know what, like you have to do what the lawyer says, or you have to do what the Crown says. And I'm just wondering how much you communicate with the Crown when advocating for a new client, and do you really recognize the uniqueness of each individual? Because I'm actually faced with one right now, and I'm feeling like I really want to strongly advocate for this person, but I'm also being told to maybe take a step back because it is an indictable offense where there was a weapon involved, not used, and first-time offense for basically a youth. So yeah, I'm just wondering, like, is that an appropriate one to advocate for?
I would say my answer is two-part. One, just acknowledging I'm a Crown, so I'm coming at it from that perspective. I would, if you were in Brampton, I would say 100% advocate for it. What my hang-up in your circumstance might be that because you are a newer program, there may, like, I could say, I would likely say yes, without knowing more about it, of course, but I would likely say yes, because we have that sort of like established, well-oiled process that we know works. When you're starting out, it may be a tougher sell because the program doesn't yet know how it's going to work out for other people. So it might be more challenging to kind of rely on past history to say, you know, we had something similar with so-and-so and this worked for whatever reason. But I would always say, I oftentimes have service providers come to me or through duty council and say, can we really take a look at this person? So I don't think it's inappropriate at all. I think that's part of the role. I don't know how the Crown's going to handle that down there, obviously, but
so a second piece to this, if you don't mind me asking, do you always require medical assessments for the application?
Never. So for us, the application is it's all self-reporting. Aside from criminal record, obviously I can access that, but the person, on our, I'm gonna put it in the thing here too. I'm gonna put our website, which has a ton of stuff on there for anybody who wants to look, and all of our application materials. We don't require any medical stuff.
Attached medical. As we know, it's very difficult to access medical and get people assessed. And even if it does happen, sometimes these assessments are, a 10-15 minute sit down with a psychiatrist who writes down what they said. So it does not capture the whole story behind that individual.
Absolutely.
And that's why I'm coming to this point where I'm like, why are we depending so greatly on the medical? And I'm being told that the medical is what they base their decision on. And I'm feeling like, well, that's unfair because there's a lot of these folks who haven't had support to access these medical assessments.
Yeah, it sounds like, just based off what you said, it sounds like it would really reduce the number of people who could apply.
Be considered.
Right. I'm putting my email address in the chat as well, for anybody who wants to reach out to me. Feel free. And all that being said, for anyone who is trying to get a program up and running, there's been a lot of places where people from our team will come and speak to your team about our experiences specifically. We can answer those particular questions, and more happy to have specific conversations, you know, like this scenario is a great example.
Absolutely. I really appreciate that. Thank you so much.
No problem. Good luck.
Thank you.
Karen says clients with many of these other background issues often came into drug court, but not for these charges. We had drug dealers, people who committed acts of crime. Yeah, absolutely. One of our criteria is we ask, do you have a violent history? Is there like some sort of violence on your record? If the answer is yes, that doesn't necessarily mean you're not eligible. It just means we want you to kind of flesh that out, because oftentimes, at least from what I've seen, there's a nexus between those violent offenses and drug use or problematic substance use. And let's say the person was high at the time of committing a particular offense, and the offense was like, I don't know, 3 to 5 years ago. To me, as a person reviewing that application, that's not a bar to them getting into the program. One of the things that we do as well is we canvass with our community partners, like our specific program community partners, whether or not they have any safety concerns. The answer has always been no, they do not. But I feel like we have to do that because we have to make sure that they're comfortable as well. In a situation where there is some violent antecedents. But, you know, when we say people with violent offenses aren't eligible, it's more so, there's a lot of gray area, but it's more so like, think homicide, violent sexual offenses, someone like, you know, someone with a firearm, you know, like the super violent offenses. Those are the ones that we automatically kind of take out of the equation. And then, like I said, there's gray area. We oftentimes have people will come in who, pardon me, you know, someone who's stealing from the LCBO, and when they were stopped by police, they had a switchblade in their pocket, so they're charged with the weapons dangerous. If the person has precarious housing and nowhere safe to stay, or they stay at a shelter, it's not much of a stretch to understand why they would have a weapon on them, perhaps for self-defense. So for us, that's not an automatic no either. So it's really case by case, but we would want that person to, either through their lawyer or themselves, to work through that with us. Like, it's not just a, I'm not going to make assumptions based on a synopsis or someone's representation through their past criminality that they are or are not eligible based on offenses and whether they're offenses of violence. I want them to articulate that the best that they can to us.
All right. Thank you so much, Jen, for sharing your insights, sharing all of the principles and the work that you've engaged in, and furthermore for sharing your contact information. I imagine there'll be quite a few emails coming your way, and then also for opening that door to further the great work that's happening in Brampton across the province. And so a few more housekeeping notes from me. I have put the evaluation link and the session title into the chat. So please, now that this session is done, I encourage you to provide your feedback on the session. That will help us inform this work and future conferences. And also, we are almost done our conference. There is a closing ceremony that is currently happening, so you can join us there for our closing remarks. And my final note is, again, this session is recorded. The recording is available for the next 3 months, so you can use this login. You can come back into the site. You can view the recordings. I think that is it from me. So I'm going to wish everyone a happy and healthy rest of your day.
Thanks,
Take
everybody.
care. Thanks so much.
Jennifer.
Thank you.